Welcome everyone. My name's Lee Godden, and on behalf of the Director of the Institute for International Law and the Humanities and the Centre for Resources, Energy and Environmental Law, I'd like to welcome you all to this wonderful event, the launch of the Recognising Personhood special issue of the Griffith Law Review. I will just say a few very quick words. The event that gave rise to this is indelibly printed on my memory because I broke my knee on the day when I was to attend. Now, I'm very happy to be able to be standing here today, some 2 years and more on, with a wonderful collection of speakers and a range of multinational inputs. And so I would like to begin by acknowledging myself, the traditional owners of the land and waters, the Dja Dja Wurrung, on which I'm located. But it's now my great pleasure to hand over to Uncle Toby Garvey to begin a formal welcome on behalf of the Wurundjeri peoples. Thank you.
Thank you very much for that warm welcome. First, I'd just like to start off with saying Wurundjeri to everyone. So Wurundjeri in the Wurundjeri Wurrung language means welcome. So welcome to all Indigenous and non-Indigenous people here today. I'd also just like to say I'm very proud and honoured to be here today representing my people, the Wurundjeri Wurrung people from the Yarra and surrounding areas. My great-grandfather was the last Nulungu after King Barak. Nulungu means the last tribe leader, and my uncle was the last person born on the mission at Corranderk in Healesville. The Wurundjeri people were also a part of the Kulin Nation. So Kulin means man. And in the Kulin Nation, there were the 5 language groups. There was the Wadawurrung to the west, the Coorong, who were the westerly neighbours to the Wadawurrung, Tunurong to the northeast, Bunurong to the southwest, and the Wurrung of the Wurundjeri territory that we stand on here today. The Wurundjeri lies within the cities of Melbourne. It extends from the mountains of the Great Dividing Range, south to the Yarra River, west to the Werribee River, and east to Mount Baw Baw. The Wurundjeri people, they have a social totem. It is Bunjil the eagle. Bunjil represents spiritual powers throughout many parts of Australia. Bunjil taught all the laws about life, behaviour and ceremonies to make sure that our culture would continue for all walks of life throughout Australia. Bunjil is referred to as the creator of mankind. Bunjil created great people from the land, and that is why we call the land our mother, or the mother of creation. Never can the land be taken away. The land will always belong to Aboriginal people, as we are part of the land and the land is part of us. Our story is similar to yours. Yours is by your chosen fate. Ours is by the dream time. We both have creators and beliefs, and ours is Bunjil. It is a traditional custom of the Australian Aboriginal communities to be asked and to give permission for people to enter their land. And today you have now joined with me to honour the spirits of my ancestors, past, present and merging, who have nurtured this land for over 60,000 years. And we, as the traditional owners of the land, offer you a heartily welcome to the land and hope that together as citizens of this beautiful country, we can build, develop and unite stronger nations for all people. And finally, I'd just like to close in my Wurrung language, which is Wurundjeri, Wundoon, Wurundjeri, Balak, Yemen, Kumbibik, which means you're the most welcome to the lands of the Wurundjeri people. Thank you very much for inviting us here. It's very important for our culture to go forward and be still recognised in this country years to come forward. Thank you.
Thank you, Uncle Tony. Could I just alert everybody to the fact that this seminar is being recorded, so just to let everyone know. And if I could now hand across to Eleanor for our multinational, transnational welcome. So please, Eleanor.
Gur míl maith agat Lee, thank you Lee, agus gur míl maith agat Galéir asocht an cuire chun sibh altu an seáinniu. Thank you so much for the invitation to welcome you here today. Go Gaillimh, go Iarthair na hÉireann, to Galway, to the west of Ireland. Bhailm cúpla línta filiocht na Gaeilge a Rheinú live. I would like to take this opportunity to share with you some Irish poetry. Agus in filiocht na Gaeilge curc an béim an dúlar nádúr an slí in a bharan bhuintear leis an nádúr. So in Irish poetry, there is a very large emphasis on the way in which the people live with the land and live with nature, which chimes very well with what we've just heard from Uncle Tony as well. And this poem that I'm going to share some of with you is written by a blind poet from the west of Ireland about his native place and how it forms him as a person, the place to which he belongs, which I think is very relevant for what we are discussing here today and the material in the special issue. Bhailm rudháin eile a Rheinú live, sin as Gaeilge nuair a bhí mid I fáiltú go éifigúil, úsáid míad an phrase a dhaoine úsle. So in Irish, when we welcome formally, we don't use gender to acknowledge people. We use the term a dhaoine úsle, which means noble people. So I just wanted to start with that as well. So leis sin, Rhaine mé an dáin le Anthony Araftre dáin Cil é dáin. Anis tachtan arig beg na láig dulcan sína is taréis na féle bríde or dóig mé mo hól. Go cuileach racha dus ní stoppa mé cuithe go seasta mé síos lár chunda bhuió. Ciléadán an baile go bhástan gach níann tá sméra súh créann is measta gach sort. Stá maintse ma cheasa bh gart lár maghuine de mócha nístam is fáin rís óg. So this poem is translated as follows. It says, with the coming of spring, the light will be gaining. It is now spring in this part of the world. So after the festival of Breed, I will set my course. Since it entered my head, I'll never rest easy till I'm landed again in the heart of Mayo. Mayo is a county in the west of Ireland. I testify here that the heart in me rises. I'll spend my first night in the town of Claremorris, and in Bala I'll raise my glass in a toast. To Kiltimach then I could linger a month there within easy reach of Ballinamore. Killeden's a place where all good things flourish, blackberries, raspberries, treats by the score, were I to stand there again with my people, age would fall from me and I would be restored. So leis sin fáilte roimh go léir a rís chuig an ócáid speisialta seo ó Gaillimh ó Iarthair na hÉireann tá míad anmhaíocht as an ócáid seo a bheith linn inniuh. So with that, thank you again for the opportunity to welcome you to this part of the world also, and I'm very grateful to be here with you all today. Thank you.
Thank you.
And now I'd like to hand over to the two people who've really been the driving force, both in the initial event that Creel and Illa hosted, but also in moving forward with the special issue on recognising personhood. So if I can now hand over to Anna Arstein-Kerslake and Erin O'Donnell, and they'll really move the rest of the seminar forward with you in conjunction with our contributors and our audience. Thank you.
Thank you so much. I think Anna and I are both thrilled to be here launching this special issue. This special issue came about from a chance conversation between Anna and I at a conference. So I think from the very get-go, it's been a kind of academic labour of love that has been building conversations across different legal disciplines, centering on this idea of legal personhood and the changing way that we understand and articulate legal personhood, and particularly the role of the state in enabling and supporting and recognising new forms of legal personhood. So it's been a really exciting journey. We are so pleased and happy to have so many people who've been on that journey almost as long as we have. And we're really delighted with the way that a number of international contributors have also embraced this special issue and joined a conversation with us as we've delved into some of these new developments around personhood. And I'm just going to give you an opportunity to say any opening remarks you want to, and then we can move into the substance.
Sure. Excuse me. Thank you so much, Erin. Yeah, just want to reiterate that we're so thrilled to have everyone here, to have everyone's contribution to the special issue, and to be continuing to build these conversations, as Erin said, around what personhood is, why it's important, what the state's role is in recognizing, supporting, and understanding personhood. And I think this collaboration that, yes, began with a conversation that Erin and I had in a hotel, actually just outside a hotel conference. It has really, I think, for me personally, been a vast expansion of my work. I think drawing on all these different disciplines and all this different knowledge across so many different spaces and so many different environments and different types of knowledge. I think it's really expanded my understandings, and I think that's hopefully what we're trying to do, is to share that with many others, the potential expansion of knowledge, and I think the power of this knowledge and the growth of this knowledge relating to personhood. So thank you so much, everyone, for being here.
So to get us started, we thought we'd give you a bit of an overview of the special issue itself and some of the debates that really prompted us to enter this scholarly conversation around legal personhood. It is a long conversation. You're heading off, Uncle Tony?
Yeah, I've got a bowl. Yeah. It's tea time.
Yeah.
I got my wife cracking the whip.
Well, thank you so much for joining us.
No worries. Thank you for inviting us. Much appreciated. Thank you.
All right. So while Uncle Tony logs off then, where was I going with that? So yes, it is a long conversation around personhood. Legal personhood is one of those ideas that has characterized the law in Western countries for hundreds of years, and trying to understand what the law means by that, the rules that the law sets for itself in terms of who can be a person, who should be a person, who is a person, what personhood actually means, what rights and powers and duties and responsibilities come with that. This has been a long, ongoing conversation, and many of the scholars here tonight have been contributing to that for a long time as well. So the starting point for us was really the significant and substantive shifts in theory and law that have really characterized the 21st century so far when it comes to legal personhood. We've seen profound legal commitments to the full personhood of disabled people. We've seen dramatic new expansions and applications of personhood to natural entities such as rivers, mountains, forests, all kinds of natural landscapes. Despite my initial expectations that this might be a sort of flash in the pan and then begin to die away, the rights of nature movement has continued to build from strength to strength as more countries begin to embrace this idea of recognising nature in various ways as the subject of legal rights or a living entity. There are ongoing debates around the legal personhood of animals, and of course we've had foundational cases recognising that personhood, including, I think, some hippos in Cuba. So we've had ongoing debates around artificial intelligence. This is an area which is really rich in its scholarship and the growth, I think, of debates around personhood. And of course, we still have conversations about corporations, what rights and powers they have, how they relate to human rights. So I think we're all still reeling a little bit from the Hobby Lobby decisions that started to infer that corporations began to have some of the rights that we typically associate with people. So for an idea that is so foundational to law, this is an area that is still the subject of extraordinary debates. And if we could just quote here for a second from Anna Greer, she said almost 10 years ago, I think now, the subject of law's subject has become a topic of growing contemporary concern in ways that highlight law's limits and the inadequacy of its constructs to mediate the complex, organic, shifting, embodied, mutable, and situated affectability of the socio-material and spatio-temporal aliveness woven through, beyond, and beneath law's systemic closures. So again, there's this recognition that law's personhood needs to do much more than speak to just legal theory. And if we look at, again, at just another quote from a scholar who's closely associated with these conversations on personhood, and this is from Nari Nafeen. And she says, legal personhood serves a social and expressive function and therefore is not fully internal to law. It sends a message to the community and expresses, on behalf of that community, who or what is to count, who matters to the law. She also goes on to note that because the adult, rational, autonomous, non-pregnant human tends to be the paradigmatic person, this being possesses not only the best set of rights, but also the personal power to enforce them. This being fares best in law, is best suited to law. So again, there's a recognition that the way that law has historically understood personhood perhaps is not well suited to the current context and the current socio-legal conversations that we're having. And it invites us to consider not only questions of a positive definition of legal personhood, what is a person, but these normative questions of who should be a person. And I'm just going to hand over to Anna to pick up the threads of that.
Thanks, Erin. That's I mean, we planned it, but that's a perfect transition to what I wanted to just mention briefly, which I think is for Erin and I, in a way, one of our motivating factors, I would say, or maybe something that really sort of impassions us, and that is sort of challenging this this construct of legal person and how it has developed, especially in Western legal traditions over centuries. And as Erin was discussing, that conception of personhood is an atomistic, so isolated, or let's say independently autonomous, male, who's white, who's cisgender, who's able-bodied, and who attracts an assumption of personhood. And I think perhaps the irony of that is that the number of individuals or entities in the world that fit into that quite complex category actually is actually very small. It's not representative at all of our world, either human or natural. And I think something that really highlighted for Erin and I that our work is connected, even though mine is really focused on disability and Erin's is really focused on the environment, was that we were both working towards challenging these very rigid historical boundaries around what is a legal person. And as Erin highlighted from Nafeen, from the quote from Nafeen, it is those boundaries, it is within those boundaries that power exists, social power, legal power. And so it's I think critically important that those boundaries are broken down and expanded to include everyone within our social world, within our environmental world, everyone that needs protection, everyone that needs rights and the freedom and support to act on those rights and have those rights enforced. And I'm using rights language because it's what I have in front of me with the knowledge of the downfalls of rights language as well. But I hope that that's sort of a good overview of maybe what's sort of pushing us forward in this work, the desire to move beyond what we have that really has privileged a very small group of people who have historically had power. I think these conversations around what is personhood, what can personhood be, what have different legal traditions, such as Indigenous law, already understood about personhood that hasn't been incorporated into the Western legal tradition, but is actually critically important for equality and for protecting not only humans, but our whole world and our environment around us. With that modest goal, we put together the workshop in 2019, which many of you were at, and coming out of that workshop again is this special issue. So I might now just turn to introducing the papers. And I'll do the first three, and Erin will will introduce the rest. And then we'll open up to discussion of the content of the special issue and the papers within that. So the first three papers include Michelle Worthington and Peter Spenders, Visa Kirkies, and Eleanor Flynn. Michelle and Peter's paper takes a really interesting analysis of corporate law and applies it or analyzes it in the context of nature and discusses the implications that the development of corporate legal personhood has for natural entities. Visa Kirkies' paper looks at legal personhood, and I think it's important to mention incorporates discussions of moral personhood and important threads of philosophy, and does that all in the context of children, which is often an overlooked cohort in terms of, especially in terms of recognizing personhood in a way that gives voice. Then I think perhaps a sort of paper that is important actually for these first three papers, and actually important for the broad discussion of what is a legal person, is Eleanor Flynn's paper, where she discusses the power of language. She's talking in the context of disability rights, but the importance of language crosses all of these different disciplines, and all of the different areas where legal personhood can be applied, because it really is the language we use that allows us to understand or not understand across cultures, across cohorts, across power, across privilege, what personhood is, what we're discussing, and the power to manipulate language as well is highlighted in Eleanor's article, and I think it is also something that needs to stay at the forefront of our minds when we're having these conversations and developing ideas of personhood, language around personhood, and really trying to actually pull power away from the central group of, again, white, male, cisgender, able-bodied men, mostly, or that construction of the legal person that has largely existed and continues to exist today. Pulling power away from that location, I think, requires a really careful examination of our language, and how it can be used against us or different groups, and also how we can use it as a powerful tool for creating change and expanding understandings of personhood. I'll just pass over to Erin now to discuss the remainder of the the next papers.
Thank you so much. And I just noticed that there was a question pop up in the chat about where is our exciting special issue, so that you can go and read it all for yourselves. In typical academic style, I will note that Anna and I have delayed the launch of the special issue because unfortunately our editorial is still moving through the proofing process. So it will be launched or available as soon as humanly possible. I believe we've now submitted the final changes. For now, there is, I think Christy's posted a link. If that hasn't come up for everyone, please somebody just pop another question in the chat and we'll share the link, because all of these papers are available now as well. So they're available in the sort of online early view. And so you can have a look at all of them. Many of them are available as open access as well. But all of the authors, well, at least one of the authors from most of the papers are here tonight. And so please reach out if you don't have access and there's a paper that you're particularly excited about. So the next three papers in the special issue that I'm going to talk about now are all focused on the idea of rights of nature. And so the first of these comes from Rachel Mortio, and she's looking at a novel application of the rights of nature and examining the applicability of this concept and legal doctrine to the coastal areas of New Zealand. So she documents the failures in the existing regulatory framework to protect these really special, beautiful places, and then shows the opportunity of the state stepping in to recognise those places as rights holders under the law. And she argues that the legal person model can be applied to an ecosystem and signal a shift in the societal value of New Zealanders who are willing to legally recognise that these ecosystems are no longer simply objects under the law. So a novel application. From there, we move to the paper by Liz Macpherson et al., which is the first of their papers, I believe, to come out of their Global Riverine Rights Project. This is a multinational project. In this paper, the authors look at examples of legal persons or legal subjects in Aotearoa, New Zealand, Colombia, and India. And they look specifically at the types of laws used to create and recognise legal personality for rivers. They argue that these multiple recognitions of the legal personality of rivers are attempts to transcend the normal politics and law by reaching deep into the moral fabric of a society. And so by considering these laws through that constitutional lens, they're not necessarily all explicitly constitutional examples, but it does demonstrate the efforts being made by the state to raise the profile of these conversations and these debates and the very status of these rivers. The third paper in this little set of three is a really, really important one because it's actually a really profound challenge to the rights of nature advocacy movement. And I think for all that there are tremendous transformative opportunities that come from recognising rivers and other natural entities as legal persons or living beings, and it does have the capacity to change the way that humans relate to those natural entities. Is it actually the profound challenge that we envisage it to be to anthropocentrism? Are we actually shaking up the very foundation by which we have categorized and created hierarchies in the world around us and enabled some beings to exploit other beings? So Jade Ann Reeves and Timothy Peters look at the case of Te Awatupua, the Wanganui River in Aotearoa, New Zealand, and explore how this actually challenges anthropocentrism, or even if it necessarily does. And so they argue that by recognising special cases, this might actually entrench the dichotomy between legal subjects and objects, continuing to justify the exploitative treatment of those legal objects. So is the mere expansion of the categories of legal person actually enough to really shake this up? So with that, there's two more papers that we want to talk about. I'm going to hand over briefly to Anna to talk about the paper that we have co-authored on relational personhood. And then I'm going to briefly introduce the final paper, which is authored by the Marawara River, and then hand over to Anne Poelina to have a bit of a chat about that. Just before I hand to Anna, I will say we are going to have a Q&A session with all the authors who are joining us here tonight. So if there are questions that you would like posed to the authors, please pop those into the chat function or into the Q&A box, and we'll pick up on those as well. We will have some questions to get us going, but please please add your questions into the mix as well. Anna, over to you.
Thanks, Erin. So the paper that myself and Erin authored, we co-authored with Joe Watson, who's here with us today, and Rosemary Caius, who I believe is not with us today. She's very busy and important because she is currently the chair of the United Nations Committee on the Rights of Persons with Disabilities. Her time is precious, but we were very lucky to have her with us on the article. The main thing that I want to mention about the article, or maybe there's a couple of things, and I guess I want to preface them with the acknowledgement that what we were doing, or what we have done, drawing parallels between disability and nature, is a very fraught thing to do. And that's because of the long history of people with disabilities being treated as objects. And of course, similarly, natural entities are currently treated as legal objects. And in many contexts, people with disabilities are also treated, continue to be treated as legal objects. And this parallel is a dangerous one to make, because it can often be used against people with disabilities, and to further objectify and marginalize people with disabilities. But we felt that there was also an exciting opportunity to discuss the development in both of the disciplines of disability rights and environmental law, in relation to new understandings of personhood, and better understandings of personhood in terms of personhood being relational. And I want to accentuate that this in many ways isn't a new concept. Again, Indigenous cultures, not all, but many Indigenous cultures around the world have been recognizing personhood as a relational concept for centuries. However, in Western legal traditions, personhood has been conceptualized as atomistic, individual quality that sits with the individual and essentially is the individual's responsibility, if you will. Although we discuss also the sort of the fallacy of that and the illusion of anybody being actually an isolated individual in our world. What we really are using these two maybe seemingly disparate disciplines of disability rights and environmental law to discuss is how the state can recognize the interdependence of us all, and how that can be done in the context of personhood. And I think it's important to note, maybe again, that although we're using disability and the environment to highlight this, it's not unique to those areas. And in fact, I would say it's as important for people enjoying power and privilege to acknowledge their interdependence with others as it is for people and entities experiencing marginalization and oppression. And I think what we did in this article is draw on the rich literature that exists in disability and environmental law to bring out these themes and hopefully bring them out in a way that will allow others to apply them in other disciplines and other fields in the future. I think that covers our article. I'll pass back over to you, Erin.
So very briefly, because I think Anne is going to do this tremendous justice. The final paper in the collection is lead authored by the Mudawara River itself in a profound acknowledgement of the power, presence and agency of the river as a collaborator and a co-producer of knowledge. And in this paper, which I co-authored with Anne and many amazing scholars, I think we've got some of them here tonight. I can see Afshin and Christy and Liz. So this is it's a conversation, this paper, between the river, between scholars, between Indigenous peoples, people of settler heritage, and it explores the idea of reshaping the idea of legal personhood to incorporate ancestral personhood and the relationships that we owe to ancestors and the relationships that we are in with ancestors. And so with that, I'm going to hand over to Anne to say a few words before we enter the Q&A session.
Thank you. Jada boronyigina ngayu imadwaraman and ngai mandajara nyigina ngai nyigina nganga in Broome in Jurgen and Yaru country. Thank you very much for the opportunity to come together and share this work. It takes me back to where the story started for our people, which was in the Wanganui, the Whanganui River in New Zealand. And I came back after the first Tribunal for Nature in Brisbane, and I said, oh, these Maori people and what's happening in New Zealand, and this river has got personhood. And the elders looked at me as if I was a little bit crazy, and they said, the river is not a human being. And from that, it took me back to a place, because when I introduced myself, I go, Ngayu Imarawara, which means I am a woman who belongs to the Fitzroy River, the Marawara. So the river is the construction of everything we know. It is our identity. It is the relationship with non-human and human. It is the realization that the river is a living entity, a sacred entity, which we've always known with. We cry with it, we do ceremony with it, we dance with it, we sing with it, it sings to us. And why we know it is alive is because people come here and they visit it and they lay on the riverbank and they say, hey, we heard the river waking up. It is a powerful system of energy. It is a system that has created our law from the beginning of time to teach us as Indigenous people how to live in peace and harmony with a living system that is responsible for all life, not just ours, but the right for multi-species to be part of our non-human family, to be part of what we see as the greatest challenge before the planet right now, which is the challenge of how do we create peace with Indigenous people and with nature. So I look around the world and I see these stories, and I know in my heart that it is Indigenous people who are leading the rights of nature conversation, because these unjust, invasive developments are happening on our lands. And so we've led them, and what we come back to is say that we cannot coexist without nature. Nature is what gives us law. Nature is what gives us identity. Nature is what teaches us how to have peace and harmony with the world in which we co-create a lifeway and a livelihood together. So the river is an ancient system. It has taught us all of these things. It has taught us first law of the land, not law of man. It teaches us about values, about ethics, about code of conduct, of how to live in a society that really didn't need a law. It was an alloidial society where everyone self-regulated, because we came up with the stories in which we believe that this was for the greater good of all people, because we come from a world of we, not me. So what we're doing on this journey is waking up the snake, waking up the consciousness of other human beings, because the rivers are asking these questions right across the planet. What are the humans doing? Where are we going in such a vulnerable time of climate chaos? So we look across the world and we see these stories and we say that, why have law? What is the purpose? What is the intent to have law? And so these are the questions that we have been grappling with since invasion, colonization. And what Indigenous people are saying is that we want to share these laws. We want to share these stories. We want you to share and know how to be in the world a different way. So these are not separate things. You know, why have a law? Why self-regulate? Why do these sorts of things? So it is about balance. It is about peace. It is about harmony. But the river has made the laws, not a human. A river has provided the way for us to see the world over thousands and thousands and thousands of years of how to understand the system, how to manage it, how to live with it. The water, the serpents have taught us what is water justice, what is procedural justice, what is distributive justice for all. So we come from a world, as I said, of we are doing amazing things up here in the Fitzroy River, but at the end of the day, we are grappling with the same stories that other human beings are grappling with across the world, in terms of looking at the fact that the laws, particularly environmental laws, environmental policy, are totally failing. We are failing to protect the things that the law said it would uphold. So we, in terms of disability services, Indigenous people, gendered people who may be ostracized, we're saying it's time for the world to stop othering this knowledge system, this ancient wisdom which has come from the beginning of time, to show how we need to go back to the ways that we saw that we were not on the planet as isolated beings, but with our fellow non-human family. So there's lots of stories, there's lots of journeys, there's lots of wisdom, because what we're dealing with is complexity. And when I look across the panel and I see Ashen and Liz and Erin and Alessandro and all of the friends who have stood to be a friend of the Marrawara, we are learning together because we need collective wisdom. We are dealing with complexity. We need to throw ego out, bring eco in, and balance up the world that we have misogynized. So what we do is we tell stories, we sing songs, we share. The river is and has its own agency and is now a published author out there in the world, creating this way. So the story really is, this is an emergence of a conversation around ancestral personhood. There is a lot of places that it needs to go and needs to do a deep dive. But what we're seeing as Indigenous people is that the laws and the policies in protecting nature and protecting environment, and most importantly, Indigenous people, are failing at every level. And so we need a resurgence to capture the hearts and minds of the people and bring them on the journey. And that's what we call wake up the snake, wake up the consciousness of the people, because the IPCC is saying this. Without the ancient knowledge and the wisdom of Indigenous people, we will not be able to right-size the planet. We need to stop being othered, we need to be brought in, and we need to share the collective wisdom in terms of how we coexist in a world that we can dream to be beautiful and available in 10 years' time. And so these are the stories that we tell. So yeah, thank you for the opportunity to share with you. If you have a moment, I'd like to read a poem if that's possible.
Please do.
It's called Marrawara Time. Marrawara, the Fitzroy River tributaries, floodplains, gillas and soaks mark the sites where the Yungarugu, Galburu, Galburu, Mungabu and Gurung give life to the rainbow serpent's first law, law for water living free. The river is watching in the waiting time, waiting to see what the humans will do. Lots of talk of water planning, water allocation, licenses too. Somewhere in there is a hook, uncertainty. We will give some water to Aboriginal people, not sure what the number is, but it's likely to displease. We took it from the territory, 30% was the failed model decreed. What do the people of the Marrawara do? We know water markets, water trading is all about greed. Greed's got them beat, my ngunu would say. How could my sister have known what was coming our way? Don't worry about what you can't do. Get on with what you can. Her spirit still guides me, and I know she has a plan. Living with whiteness, colonialism, divide, conquer, manipulate and rule. First the land, then the slaves, now the water. What is going to be left for blackfellas was the elders' cry for water justice. 8th of October, the United Nations did decree it's a human right to live in a clean environment, free from contamination, polluted air, misery. Clean environment, free from contamination, not to be poisoned, cheated, defrauded in rules, designed for the predatory elite. Don't ask for a statutory process, procedural fairness, distributed justice at the same time. We are in the waiting time, waiting for government and the big corporations who will determine the greater good for themselves, not for mankind. Trade off water interests, not water rights. Trade off lives, those of our kin, the birds, the fish, the trees, the air and the sea breeze. Canning Basin is shaking from the tremors over the past years. It still can't believe. Stop. This would be the biggest man-made destruction in the world. Maybe somewhere amongst these grid lines, there are some happy fat cats fracking up the river country. No comparison with the Canadian tar sands. This will be forever wrong. Imagine if they invested $1 billion into our region, our people, our lifeways, our livelihoods, transitioning coal into renewables with no new gas coming online. No one wants stranded assets to meet the transition energy deadline. Songlines singing, we want to see just energy transition for these families to be free. River country watching and waiting in this modern dream time. I know you hear me, you feel me, I feel you too. Write these words down and dream me to you. Tell the city people about me, tell them all to stand and come. There are secrets here, and I am the largest registered Aboriginal cultural heritage site. We have been promised never again, but I am fearful ecocide and genocide we will become. They don't seem to be listening despite 50,000 good and decent human beings asking government's meaning from these songs. Protect Madawarra Fitzroy River, protect me now and forever. Madawarra Fitzroy River always was, will it always be? They came from the east singing this song to thee. Serpents swim together, waiting for the Warrumba and the Gudgeon waters to rise. We wait, we twist up into the skies and down into the underground. We hold the songlines, the stories and the forever memories. First law, Wallangari law, we all dance, moving and rotating the circle and the men sing the song. Wallangari people, Daisy Bates claims, dance together to hold the Madawarra law song. When we stand united, we hold the dream time from past, present and future, and we sing together a new river time song. Kalia Mabu, thank you.
Thank you so much, Anne. I'm seeing a lot of people applaud, and I imagine a lot more are applauding that we can't see on the webinar. Thank you. It's, yeah, every time I am privileged to hear you speak, every time it's amazing. So thank you for your energy. Thank you for your words of wisdom. From that, I'm now going to try and move into a Q&A if we can all regather and recenter ourselves for that. I think Anne's throwing down some really important and profound challenges to us as legal scholars, but also to us as human beings. So we should hang on to that. But let's now return to some of the other authors who are with us tonight as well. As I said, we've got a few questions to kick things off. If you have questions that you would like to pop into the chat, we'll try and make sure we get those. And I'm going to start off with the first question, which is going to go to Peter and Michelle. And the question is, new examples of personhood underscore the importance of what we can learn from the ongoing scholarly debates on the corporation. What would you say is the key insight from the work on the corporate form that can start to inform these new developments about personhood for new entities like rivers?
So Michelle, did you want to start?
Yeah, thanks, Peter. I will. And thank you, Anna and Erin, for organising this. And I wanted to mention that I'm dialing in from Ngunnawal and Ngambri lands tonight, and to pay my respects to the elders of the Ngunnawal and Ngambri people. In answer to your question, my thinking on this, and I don't think I'm burling Peter if I say that I think we probably agree about this, is that purpose, the immediate purpose of a particular legal personality is really critical to the safe and effective design of legal personality. And if there's one thing that we can definitely learn from the development and the deployment of the corporate form, it's that losing purpose as a guiding regulatory factor is a really dangerous thing to do. So it used to be the case that corporations were regulated according to purpose. They had to nominate initially a public purpose and then later just the purposes of the enterprise. And then the conditions and the capacities and the obligations were matched to the purpose. But over time, that purpose requirement was lost, and a purpose was put in its place as a sort of default working purpose. And that purpose, unfortunately, is a profit-focused purpose. So just drawing on the what we consider to be the really cautionary tale of corporate development, I would definitely say having a purpose for a legal entity that is immediate to its function and which is put in place right at the start of the development process is really critical.
Yeah, thank you. Peter, did you want to add to that as well?
Yeah, just the only thing I'd add is just that idea about what we call unitariness of the legal personality of the corporation is really quite important to its design, and it's something that is being challenged by a lot of the papers in this special edition. And so it's really important to read that unitariness that sits in the law of corporations alongside the relational concept. So yes, that's all I'd add to that. Yeah, thank you.
Brilliant. If we get time, I'm going to come back to that concept of unitariness. But for now, I think I'm going to hand back over to Anna for our next question.
Yeah. Sorry, thanks, Erin. Yeah, and this question is for Eleanor and Visa. So both of your articles talk in various contexts about recognizing the personhood of children and disabled people, and they come at the problem, I think, or the issue from very different perspectives, and I think you actually arrive at quite different conclusions as well. So we might, I think we would just love to hear from both of you sort of how you deal with the issue of recognizing personhood for children and disabled people respectively, and sort of what your conclusions are around this, and maybe where you sort of are hoping that scholarship goes. Visa, maybe do you want to start and then we'll go to Eleanor? Oh, sorry, Eleanor.
Sure. So thanks for the question. So my sort of, by the way, greetings from Helsinki. I think I may be the only participant from this part of the world, and by the way, a country sharing a very long land border with Russia. So I think I've been a bit preoccupied with some other things the last few days. But anyway, so my approach in the paper and more generally to legal personhood is something that's often called like analytic legal theory. So I'm very interested in sort of getting the concepts right in a way. And in my more like broader theory of legal personhood, I distinguish between passive and active legal personhood. And passive legal personhood is something that, for instance, infants have, meaning that they can't sort of perform legal acts on their own, for instance. So we don't hold them responsible for their actions. They can't decide about any affairs on their own, for instance. And traditionally, in sort of when theorizing about legal personhood, there's been a rather sort of a strict divide between passive and active legal personhood, and children have often been understood as being sort of purely passive, so they can't decide anything on their own. But then there's this a lot of recent developments in sort of international child law and children's rights that sort of demand that more autonomy be given to children. They should be deciding things on their own, or at least not be left out of sort of where the decisions are being made. And it's that what I try to analyze in the paper. So what I suggest is that between this sort of traditional passive legal personhood and this sort of active independent legal personhood, there's like a middle category that I call dependent legal personhood. And that what I mean by that is that children, as they gradually grow older, they can make more and more decisions, but often they can't do these decisions completely on their own, but rather the parents may have sort of like a veto right, or maybe the parents have to be consulted, or in some cases it might go the other way around. So the children start getting a veto in some decisions. And then I mostly use Finnish examples. So for instance, in Finland, I use the example of which religious community to belong to. So, for instance, when a child turns 12, the parents can no longer force the child to move from one religious denomination to another. And then when the child turns 15, it goes the other way around. So the child can on her or his own decide to change religious denomination, but the parents have a veto. So there are all sorts of these interesting middle categories. Thanks.
Thanks. That's really interesting to think about. I suppose in my approach to the topic, I would sort of challenge us to move away from using standards and thresholds around cognition and rationality to determine what kind of personhood people should have. And people or entities, I guess, in light of the broader conversation that we're having. But obviously I'm focused on natural persons and on the specific challenges that have been presented to disabled people in exercising, in having their personhood recognized and then in exercising it. And I'm interested in the interrelationship between those two concepts. So one of the things that I explore in the paper is how states in the negotiation of the UN Convention on the Rights of Persons with Disabilities, and since its adoption, have been, of course, saying, of course, disabled people are persons before the law. Of course, we don't want to deny their existence as persons. But when you drill down into what does that actually mean, many states are incredibly reluctant to confer any rights alongside that personhood in terms of exercising. So they're like, well, yeah, we'll just recognize you at a symbolic level. But of course, there's no meaning attached to that in terms of what you can feasibly do within the law. And that is very dangerous. And I think that there is an increasing co-option even in the efforts to engage in law reform around legal capacity and supported decision-making, a co-option of terms. So, and I'm writing mostly about the Irish context, of course, but in this context, there was an understanding, a quick learning by policymakers and by officials drafting legislation that, you know, the term guardianship was bad, for example, when it referred to adult humans, and we should not be using guardianship, but we'll just use another word, but we won't change the definition. And I think we, you know, what we're being called on to do with this radical shift in the UN Convention is to not just relabel the existing concepts, but actually to change their meaning. And I think it's that attempt to change their meaning where states are really struggling and getting things wrong, and where disabled people have the knowledge as to how that meaning could be changed, and they're not being listened to and respected with that knowledge. So that's one of the things that I think it's really important to explore. And I think the same is true of children and youth, for sure. And in fact, there's even more reluctance, I think, there to recognize, and where there has been a recognition of not just a symbolic conferral of personhood, but an actual exercise of rights, it returns very quickly to some of those issues around rationality and cognition, which are deeply problematic, particularly for disabled children and young people. So yeah, we could talk about this all day, but I'll leave it there in terms of my initial approach to the challenges and thinking about the issue.
Wonderful. Thanks so much, Eleanor and Visa. I think you both raised really interesting questions around how we recognize or don't recognize personhood for children and disabled people. And of course, those intersecting categories there as well, disabled children. I think we might just go quickly over to Joe Watson, who was a co-author on the article with myself and Erin and Rosemary Caius. But I think, if you don't mind, Joe, I think your contribution to our article, looking at sort of that relational aspect of autonomy and personhood and sort of circles of support is maybe particularly relevant, following on from Visa and Eleanor's comments. Would you want to give us a bit of an overview there?
Yeah, just very quickly. I'm conscious there's lots of people to speak. So Eleanor, you just so beautifully articulate so much of what I want to articulate around that hierarchy of personhood that is often based on in cognition. And so that's one of the things that I've been working on for a long time. How can we change that concept of personhood so it isn't so reliant on somebody's cognition or an entity's cognition. And my work with people with severe and profound intellectual disability in particular was around that. How can we realise personhood for this group of people who really traditionally and for a long, long time have been denied personhood and continue to be denied personhood? So that's where Erin and Anna and I and Rosemary sort of got together, and our intersecting interests came to the fore, where we were interested in how this concept that we have developed as part of supported decision making for people with profound intellectual disability, this concept of relational autonomy, which, as Anna has said, is very much not new. It's certainly been in Indigenous law for a long time, and feminist theory, you know, this is what we've drawn from. But what I use within my practice as I'm not a lawyer, I'm a speech pathologist, is this idea that people with severe and profound intellectual disability can have their will and preference realised, and therefore their personhood realised, with support from people who know and love them. And where so I have developed a model of support decision making for this group that asks supporters to acknowledge, interpret, and then act on an individual's expression of will and preference. So what we've done in our paper is overlaid that model on the environment and had a look at what we can learn from that idea of relational personhood, relational autonomy in the natural world.
Thank you so much, Jo. And I think that's a really great segue now into some questions around the rights of nature. Now, I am just going to flag, we are running a little bit late, so I hope people are able to maybe hang on for another 5 or 10 minutes at the end, just so that we can have a couple more questions. So one I want to go to that's come in from the Q&A in the chat function, and it's from Natalia. And she wants to know, in practical legal terms, what is the added value of recognising personhood of ecosystems in legal regimes where access to a court is open to environmental defenders in some way, and therefore that there's some ability for ecological damage to be addressed? I'm going to direct this question towards Liz Macpherson, probably particularly, but also Afshin, if you're still around. Christy, if you would like to jump in. Maybe, yeah, let's start with you, Liz.
Yeah, this is something that we actually ask at the end of our article about riverine rights and constitutionalism, and as part of the special issue. Should say I'm coming from Ngai Tahu Ngāti Wheke country in the South Island of Aotearoa. And I think that what our research is looking at is really, as environmental lawyers and Indigenous rights lawyers, we're constantly frustrated by the failures of environmental law, which Anne was talking about earlier, and the idea that we can maybe go to a higher level and appeal to higher, superior norms, maybe constitutional norms, to try and get over the day-to-day kind of trade-offs between environmental protection and development. And that is, that is what is part of the promise of some of the legal person cases or the rights of nature cases, is this idea that maybe we can go to a higher level constitutionally and we can try and stop some of the decision making and permissive decision making around environmental development. But as the question from someone attending the seminar has pointed out, well, in a lot of the countries where we have these developments, you in fact already have broad public interest law standing for environmental issues, and you can already go to the court often, even if you haven't been personally affected, but if the environment has been damaged in some way and you feel concerned about that. So do we need rights for nature? Do we need legal person models? Do we need the right to go to court and sue and be so as a legal person in order to protect the environment? And maybe the technical legal answer is, a lot of the time, maybe we don't. but our environmental laws have still failed. And some of these new models, you know, things like Te Awatupua, the Wanganui River in New Zealand, what's really important about those models are their relational features and the way in which they are centred on obligations to care of people, custodians of place, to care for the resources that they are related to. As Anne says, the Marawara, she is of the Marawara, she's related to the Marawara, she has to look after the Marawara because the Marawara is her family. So I think there is something more than strictly legal that is very important about these models, and that is what we say at the end of the article. But we're also posing the question, and it's an important question, and I think that other environmental law scholars and constitutional law scholars need to continue to research that. So yes, I will put a copy of my email address in the chat if anyone wants to know more.
Brilliant. And I think Liz's paper is one of the ones which is open access. So if you jump online to that Griffith Law Review website, it's downloadable from there. Afshin, did you want to add anything to that before I move on to the next question? Pausing to see if Afshin's jumping on. No, okay, while he gathers himself and or not. I'm going to go to a question to Jade and Tim, because your paper presents a pretty profound challenge to the idea of personhood for nature. What specifically do you think we should be wary of in this space?
Jade, do you want to jump in first?
Sure. Can everyone hear me? Yeah, okay, my microphone's working. So I think when we approached this paper, everyone was talking about, you know, the massive achievements that were being made in terms of recognising the personhood of natural things. And, you know, this is wonders for environmental law and environmental protection and addressing the effects of anthropocentrism. And the aim of our paper was to really, in short, critically look at the idea of personhood itself as genealogically an anthropocentric institution in and of itself, and to ensure that there weren't other questions that needed to be asked, that it wasn't the end of the discussion in terms of addressing the effects of anthropocentrism on the environment. And one of the things I think simply is just to perhaps consider whether imposing on natural things a Western anthropocentric institution is actually the answer, or maybe there's something else outside of that, and perhaps we need to be opening our understandings, ontological understandings and relationality to nature outward, more into, you know, gaining Indigenous understandings of nature, rather than perhaps qualifying the value that we have of natural things to them having a legal personality, which is a Western institution. Tim, did you want to add more onto that?
I think that's spot on, Jade. And I guess one of the questions that we were trying to explore was what type of legal personhood is being imposed. And so, like Anna, you were speaking before about, you know, the traditional Western notion of legal personhood as atomistic, as, you know, the you know, particularly gendered, you know, male property owner, and are we reproducing that form of personhood when we expand it to other categories of entities and persons? And I guess what we're concerned about is that's what's what's occurring unless we actually start to rethink personhood itself. And there are aspects that the Wanganui River example does do that, in terms of enshrining particular values within the legislative structure. But at the same point in time, you still have reproduced a number of the traditional aspects of personhood. So we're trying to call that into question.
Brilliant, thank you. And I think that's, yeah, it's certainly something that we were trying to address as well in the paper that's lead authored by the Marawara, is to think about what other ways are there of articulating personhood, and we look around the world at the specific language that legislators and the judiciary are using to try and define personhood and why it matters so very much for rivers. And there is a sense of novelty emerging and a challenge to the way that we articulate personhood historically. There is also a very real sense of desperation. And I think some of that came through very strongly with Anne's poem today. But you can see that echoed. One of the High Court justices in Bangladesh, for instance, talks very movingly about the rivers and wetlands that have disappeared and his search for a new legal tool that could try and stem the tide of that disappearance. And so, yeah, it's an odd space, I think, where there's advocacy and desperation, that desperate search for something new that Liz was talking about as well, and then coming up against the challenges of re-entrenching the existing system. So on that note, I note that we are 7 minutes over time. Is there any other kind of final question? Otherwise, I'm going to hand over to Anna for a closing comment. Over to you, Anna.
Thanks so much. And I think that's actually a really wonderful note to wrap up on, because I think challenging even the construct of legal personhood and challenging its value is a really important part of this conversation. I think that there's I think perhaps an unfortunate power in Western legal systems, and legal personhood is in many ways at the core of the power that an individual or entity can get from the Western legal system. But I think it is also really valuable to actually challenge whether we want to reinforce the existence of that power in legal that lies in legal personhood in the Western legal system. I think these are all really important questions, and I hope they have been interesting for everyone here today. And I really look forward to continuing these conversations in various different forms. I think the value of reaching across our different disciplines is absolutely evident, and I really hope to continue all these conversations with you all that are here today, and with others. I hope we can bring more people into these conversations, because I think they're actually expansive conversations that deal not only with kind of, in a way, the relatively small issue of what is legal personhood, but also what are all of these different sort of arms of power that branch out beyond or from maybe this construct of the legal person, and what do they mean for us in terms of balancing power and privilege in our world. So thank you everyone for being here today. As we've said, I think all of the articles are available online, except our editorial, which will be available soon, hopefully in the next couple days. And yeah, please everybody stay in touch, and we will, Erin and I are planning on continuing this collaboration and continuing work in this space. So we will be in touch with all of you soon to invite further collaboration. So thank you very much, everyone that's here, and thank you, Anne, in particular, for your amazing presentation and your amazing contribution. Yeah, I hope you all have a wonderful evening or a wonderful day, and hope to see you all soon. Thank you.